Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. In my previous video, I was discussing about the journey of a civil trial. I discussed about discovery and inspection. In this video, I will be starting from admission. Now, under Order 12 of the CPC, either party may call upon the other party to admit within 7 days from the date of service of notice any document saving any exception provided in the law. In case of refusal or neglect to admit after such notice, the cost of proving such document shall be paid by the party so neglecting or refusing, whatever the result of the suit may be, unless the court otherwise directs, and no cost of proving any such document shall be allowed unless such a notice is given, except where the omission to give the notice is in the opinion of the court saving of expenses. Now, the next stage is the framing of issues. Under Order 14, the framing of issues is a job assigned solely to the judge. Issues are framed in accordance with the provisions of Order 14, Rule 1 of the Civil Procedure Code. Rule 1, Sub-Rule 1 states that issues are material propositions of the facts or the law which is affirmed by one party and denied by the other. Subrule 2 states material propositions or those propositions of law or fact which a plaintiff must allege to show a right to sue and a defendant must allege in order to sue his defense. Subrule 3 states each material proposition affirmed by one party denied by another form the subject of distinct issues. Now the next stage is summoning and attendance of witnesses under Order 16. On the date appointed by the court and not later than 15 days after the date on which issues are settled, the parties shall present in the court a list of witnesses whom they propose either to give evidence or to produce documents. Now, the next stage is the hearing of the suits and the examination of the witnesses under Order 18 of the Civil Procedure Code. The plaintiff is entitled to have first right to begin unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of relief. In such cases, the defendant has the rights to begin. The plaintiff has to state his case in front of the judge and has to submit the evidence that was earlier marked. If any evidence was not marked earlier, then it will not be considered by the court. Then the plaintiff will be cross-examined by the defendant's advocate. The witness from plaintiff's side will also have the power to appear in the court, which are also cross-examined by the defendant's lawyer. The defendant also presents his side of the story supported by his witnesses and evidence from his side. The evidence needs to be marked earlier by the court, otherwise it will not be considered by the court. The plaintiff's lawyer will then cross-examine the defendants. Now the next stage is the arguments. Once the evidence from both the sides are over, then the suit is kept for argument. Once the evidence has been submitted, the cross examination is conducted by the plaintiff and the defendant. Both sides are allowed to present a summary of their case and evidence to the judge in the final argument session. Now, the next stage is the judgment under Order 20 of the CPC. Judgment means a statement given by the judge on the ground of which the decree is passed. The court, after the case has been heard, shall pronounce judgment in open court within 1 month of completion of arguments or as soon as thereafter as may be practical, and then the judgment is to be pronounced. The judge shall fix a day for that purpose. Now, the final stage is the preparation of decree. Order 20, Rule 6, Sub-Rule 6A says that once the judgment is delivered by the judge, a decree will be prepared by the concerned clerk. Now, there are certain other provisions such as appeal, review, and revision, which comes after the judgment has been finally given. An appeal may be an appeal from order or an appeal from a decree. All the orders are not appealable, and complete discretion of appealable order has been given in Order 43 of the Civil Procedure Code. Review and revision may also be preferred by the parties as the circumstances may give. Thank you so much for watching the video, and please subscribe to the channel for further and daily updates.